I was asked to write an article about the case involving a Nevada church and the order of the Nevada governor limiting the size of their worship services. As frequently happens, a little research showed that most of the reports bear a little resemblance to what actually happened. So we'll look at that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here once again with the Constitution Study, where we read and study the Constitution, where we teach the rising generation to be free. I am glad you could join me. I am very glad you could join me. As always, I'm going to point you to the website, constitutionstudy.com, where you can find out everything I'm doing at the Constitution Study. I'm working on some webinars, so if you'd like to learn more, if you have a suggestion for a webinar you'd like me to put on, please contact me through the website. Let me know. I'm developing these and scheduling these as we speak. So that I would really love your feedback. You can also sign up for the newsletter. You can get these messages delivered directly to your inbox when they're published. You can find out where I'm speaking. You can invite me to speak at your event. All of it's right there on the website. That's the best place to get in touch with me. And with that, let's talk a little bit about this article. Most of the news I found resembled this AP article from the Tennessee Star, from Reno, Nevada. A sharply divided U.S. Supreme Court denied a rural Nevada church's request late Friday to strike down as unconstitutional a 50-person cap on worship services as part of the state's ongoing response to the coronavirus. The title and opening paragraph of this article are blatantly misleading. The article goes on to poorly describe how the members of the court voted and spent several paragraphs describing the dissenting opinions. It isn't until you get to the 10th paragraph that you find out this was not an opinion of the court. It was a decision not to issue an injunction while the case is being heard. From court documents, I found that Calvary Chapel Dayton Valley is suing, notice the present tense, they're suing Governor Steve Sisolak. The church brought suit in federal district court, which refused to grant them relief. And while the case is pending appeal, the church applied to the Ninth Circuit Court for an injunction, allowing them to hold worship services under the same capacity restrictions as the governor's order places on several other secular gatherings, including, by the way, casinos. Now, the Ninth Circuit denied the request for an injunction. The church then appealed to the Supreme Court of the United States for that injunction. It was that request that was denied by the court on June 24th. Not a request to overturn the law. Now, the justices who concurred with the denial, well, they did so without comment. But the opposing justices published interesting dissents. Now, since the court did not comment on why they denied the injunction, the only information I could find on the Supreme Court website came from the dissenting judges. So, quoting from Justice Alito's dissent, quote, Calvary Chapel Dayton Valley is a church located in rural Nevada. It wishes to host worship services for about 90 congregants, a figure that amounts to 50% of its fire code capacity. In conducting these services, Calvary Chapel plans to take many precautions that go beyond anything the state requires. Yet hosting even this type of service would violate Directive 21, Nevada Governor Steve Sisolak's Phase 2 reopening plan, which limits indoor worship services to, quote, no more than 50 persons. Meanwhile, the directive caps a variety of secular gatherings at 50% of their operating capacity, meaning that they are welcome to exceed and in some cases far exceed the 50-person limit imposed on places of worship. As Justice Alito notes, religious services are being targeted for greater restrictions than other non-religious activities. Now, while the state places cap on many gatherings at 50% of their operating capacity, Directive 21 restricts worship services to no more than 50 persons, regardless of the size of the facility. From Directive 21, effective on 12:01 a.m. May 29th, consistent with other directives on public gatherings, houses of worship may conduct indoor, in-person services in a manner so that no more than 50 persons are gathered and all social distancing requirements are satisfied. Now, the same order placed restrictions based on a percentage of the fire code capacity on numerous other businesses and activities. Let's take a look at some examples. From Section 17, all businesses that engage in retail sales may continue to provide retail sales on a curbside or home delivery basis, or allow on-site customer access with a maximum occupancy of 50% based on the listed fire code capacity. Section 20 states, effective 12:01 a.m. on May 29th, Non-retail indoor venues, including without limitation indoor movie theaters, bowling alleys, or arcades, may reopen to the public. Indoor movie theaters operating pursuant to this section must ensure that the occupancy shall not exceed the lesser of 50% of the listed fire code capacity or 50 persons, and implement measures to ensure that all social distancing requirements are satisfied. All other businesses operating pursuant to this section must ensure that occupancy shall not exceed 50% of the listed fire code capacity, and implement measures to ensure that all social distancing requirements are satisfied. Section 26 reads, Section 18 of Directive 18 is hereby amended to provide that effective at 12:01 a.m. on May 29, 2020, breweries, distilleries, and wineries not licensed to serve food may open to the public subject to the following provisions. Bartenders, waitresses, and other employees must wear face coverings. The maximum capacity of these establishments during Phase 2 shall not exceed 50% of the listed fire code capacity. Section 28 goes on to say, effective 12:01 a.m. on May 29, 2020, gyms, fitness facilities, and fitness studios, including but not limited to dance and yoga studios, may reopen to the public. Establishments providing services for more than 10 patrons at a time shall limit customer access so as not to exceed a maximum occupancy of 50% based on the listed fire code capacity. Section 30 says, effective 12:01 a.m. on May 29, 2020, museums, art galleries, zoos, and aquariums may open to the public. Capacity at these facilities shall be limited to the lesser of 50% based on the listed fire code capacity or 50 persons. Section 31 reads, effective 12:01 a.m. on May 29, 2020, body art and piercing facilities may reopen to the public subject to the following provisions. Capacity at these facilities shall be limited to a maximum occupancy of 50% based on the listed fire code capacity. And Section 32 says, effective 12:01 a.m. on May 29, 2020, trade schools and technical schools may reopen to the public. Occupancy in classrooms and instructional areas at the schools operating pursuant to this section shall be limited to the lesser of 50% of maximum capacity based on the listed fire code capacity or 50 persons, and must abide by all guidelines promulgated by the Nevada OSHA. So, while indoor businesses such as retail stores, bowling alleys, arcades, breweries, distilleries, gyms, fitness centers, body art and piercing facilities, trade and technical schools, and it appears casinos are all allowed to operate at 50% of capacity, while the churches, synagogues, and mosques are limited specifically to 50 people, along with movie theaters and museums. For large congregations that have facilities for hundreds, if not thousands of people, a 50-person limit does seem overly restrictive. While the 50-person limit also applies to movie theaters and museums, the Constitution of the state of Nevada does not protect these activities. It does, however, protect the free exercise of religion. From Article 1, Section 4 of Nevada's Constitution, we read, the free exercise and enjoyment of religious profession and worship without discrimination or preference shall be allowed in this state. Justice Alito continues in his dissent, quote, the Constitution guarantees the free exercise of religion. It says nothing about the freedom to play craps or blackjack, to feed tokens into a slot machine, or to engage in any other game of chance. But the governor of Nevada apparently has different priorities. Claiming virtually unbound power to restrict constitutional rights during the COVID-19 pandemic, he has issued a directive that severely limits attendance at religious services. A church, synagogue, or mosque, regardless of its size, may not admit more than 50 persons. But casinos and certain other favored facilities may admit 50% of their maximum capacity. And in the case of gigantic Las Vegas casinos, this means that thousands of patrons are allowed. That Nevada would discriminate in favor of the powerful gaming industry and its employees may not come as a surprise. But this court's willingness to allow such discrimination is disappointing. We have a duty to defend the Constitution, and even a public health emergency does not absolve us of that responsibility. Now, it really isn't surprising that the state of Nevada would favor the gaming industry. However, I am not at all surprised that the court is willing to allow this discrimination, as I have documented several instances of the court doing exactly that. The U.S. Constitution protects the free exercise of religion from federal infringement, not state infringement. Why? Well, the First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. No, it is the Nevada Constitution that protects the rights of the people of Nevada, and the federal judiciary has no jurisdiction over a case involving a state and a citizen of that state unless it actually involves the U.S. Constitution. From Article 3, Section 2, the judicial power shall extend to all cases in law and equity arising under this Constitution and the laws of the United States and treaties made or which shall be made under their authority. While Justice Alito recognizes the governor's claim of unbound power to infringe on rights, I wish he would have spent some more time on that, using that argument to protect the rights of the congregants in Calvary Chapel. Now, Alito is not the only justice to voice dissent in this case. From Justice Gorsuch, we read, quote, "This is a simple case. Under the governor's edict, a 10-screen multiplex may host 500 moviegoers at a time. A casino, too, may cater to hundreds at once, with perhaps 6 people huddled at each craps table here and a similar number gathered around every roulette wheel there. Large numbers and close quarters are fine in such places, but churches, synagogues, and mosques are banned from admitting more than 50 worshipers, no matter how large the building or how distant the individuals. How many wear face masks, no matter the precautions at all. In Nevada, it seems it is better to be in entertainment than religion. Maybe that is nothing new, but the First Amendment prohibits such obvious discrimination against the exercise of religion. The world we inhabit today with a pandemic upon us poses unusual challenges, but there is no world in which the Constitution permits Nevada to favor Caesar's Palace over Calvary Chapel. Now, Gorsuch is mistaken about the 10-screen multiplex, seeing as Section 20 of Directive 21 states, indoor movie theaters operating pursuant to this section must ensure the capacity shall not exceed the lesser of 50% of the listed fire code capacity or 50 persons. He does provide a vivid description of the discrimination taking place in Nevada. Sadly, as with other judges, he places the opinions of other courts that the First Amendment applies directly to the states above the actual language of the amendment. Now, Justice Kavanaugh also provides fodder for why Section 11 of Directive 21 is problematic. Quote, "Under its current reopening plan, Nevada allows restaurants, bars, casinos, and gyms to grant entrance up to 50% of their total occupancy limit, no matter how many people that may be. For example, a casino with a 500-person occupancy limit may let in up to 250 people. By contrast, places of worship may only take in a maximum of 50 people, without exception, regardless of the occupancy cap. So unlike a casino next door, a church with a 500-person occupancy limit may let in only 50 people, not 250. Nevada has offered no persuasive justification for that overt discrimination against places of worship. The risk of COVID-19 transmission is at least as high at restaurants, bars, casinos, and gyms as it is at religious services. Indeed, people congregating in restaurants, bars, casinos, and gyms often linger at least as long as they do at religious services. And given the safety measures that Calvary Chapel and other places of worship are following, including social distancing, mask wearing, and certain additional voluntary measures, it is evident that people interact with others at restaurants, bars, casinos, and gyms at least as closely as they do at religious services. In my view, Nevada's discrimination against religious services violates the Constitution. To be clear, a state's closing or reopening plan may subject religious organizations to the same limits as secular organizations, and in light of the devastating COVID-19 pandemic, those limits may be very strict. But a state may not impose strict limits on places of worship and looser limits on restaurants, bars, casinos, and gyms, at least without sufficient justification for the differential treatment of religion. As I will explain, Nevada has thus far failed to provide a sufficient justification, and its current reopening plan therefore violates the First Amendment. Justice Kavanaugh adds an interesting twist to our review. He claims that the state has the authority, due to the severity of the situation, to place limits on religious organizations, and that this would not violate the First Amendment, since he is applying it to the states. Now that directly contradicts what the First Amendment says. Quote, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." It doesn't say Congress shall make no law unless there's an emergency, or unless the government has a compelling interest. It simply says Congress shall make no law. Now, if that is extended to the states, it means any law that grants the governor the authority to prohibit the free exercise of one's religion, including gathering at worship services, is repugnant to the Constitution and therefore void. Now, although Justice Thomas did not write his own dissent, he joined in Alito's dissent. So I want to make a point here. Several times I have reviewed cases where Justice Thomas notes that the original intent of the First Amendment was that it did not apply to the states. Yet here he is, joining a dissent that applies the First Amendment to the states. I'm sorry, Mr. Thomas, but you cannot have it both ways. Either the First Amendment applies only to Congress and therefore the federal government, or it does not. Period. Now, this case does bring up some interesting questions. On the one hand, as Justice Alito mentions, it is quite obvious that the governor's order is discriminatory against religious services. It does irreparable harm to Calvary Chapel and to the people that attend there, and is a violation of the congregants' rights to freely exercise their religion. As Justice Alito points out, quote, I would grant an injunction pending appeal. Calvary Chapel is very likely to succeed on its claims that the director's discriminatory treatment of houses of worship violates the First Amendment. In addition, unconstitutionally preventing attendance at worship service inflicts irreparable harm on Calvary Chapel and its congregants, and the state has made no effort to show that conducting services in accordance with Calvary Chapel's plan would pose any greater risk to public health than many other activities that the directive allows, such as going to the gym. The state certainly has not shown that church attendance under Calvary Chapel's plan is riskier than what goes on in casinos. However, since this is not based on an act of Congress, it is not a violation of the First Amendment to the U.S. Constitution, and therefore not within the purview of the federal judiciary. Now, an argument could be made that it is a violation of the 14th Amendment's Privilege and Immunity Clause. Quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. You see, but that would be a stretch, especially since Calvary Chapel apparently did not attempt to sue Nevada in its own state court. I, like Justice Thomas, want to have an injunction issued. Those who attend Calvary Chapel are suffering irreparable harm due to the actions of the Nevada governor, but that does not give the courts the authority to go beyond their constitutionally assigned jurisdiction. The best I think I could do, if I were on the court, would be to issue the injunction not on the basis of the First Amendment, but on the 14th. The privileges, both of the exercise of religion and assembly, of the citizens of the state of Nevada, protected by the Nevada Constitution, are being abridged, and the plaintiff is suffering irreparable harm. On that basis, I would have issued the injunction to protect the citizens of the state of Nevada until the case could be heard in the Ninth Circuit and possibly extended until it was heard by the Supreme Court. So what do you think? The person that asked me to review this case, I hope that gave you some insight. It's one of those, boy, I understand it is a violation of the freedom of religion. And I do want to see Calvary Chapel and their congregants protected from this infringement. But I can't condone a First Amendment challenge that doesn't involve Congress. It isn't in the language. And all the opinions of judges in the world will not change that fact. In fact, the reason this went to federal court is because we take everything to federal court because we've been trained that the word of judges, their opinion in previous opinions, precedent, stare decisis, is superior, is supreme over the Constitution itself. And that is wrong. But there certainly is a violation. It's a violation of the Nevada Constitution. It is an abridgment of the rights of the citizens of the state of Nevada. Therefore, it's a 14th Amendment violation. But if I were Calvary Chapel, I would have at least sued in Nevada State Court first because it is their Constitution that's being violated. We deal with all of these things in large part because we've spent decades misinformed. We haven't bothered to learn for ourselves. We've let other people tell us what this says. It's like the story I heard about the game of Monopoly. Hasbro did a survey because they were getting a lot of strange questions about Monopoly, and they found the majority of people never actually read the rules. They had been taught to play by other people. Well, that's what we're doing with our country. Nobody's reading the rules, not even the judges. Every lawyer I've asked tells me they don't study the Constitution in law school, they study constitutional law. The opinions of judges are what they study, and they are placed above the actual language of the Constitution. How are our rights going to be protected if the document that has those words in it isn't the standard by which we judge actions? So if you live in Nevada, please make sure, take this article, take this video, show it to the governor, show it to your state rep, show it to your state senator, show them the harm they're doing, the violation of their oath of office, and let them know that if they support this, it's a disqualification to hold office. If they will not uphold their oath to protect the Constitution, to support the constitutions of the U.S. and of Nevada, then they've disqualified themselves. And find someone who will support those things. For those of us in the rest of the country, we should be supporting what's going on as well. We should take these media that are misrepresenting what happened, and we should correct them. And if they don't want to be corrected, then do what I do with most media, and that's ignore it. When you see an article that has something interesting, don't pay attention to what the article says. Go to the source. When this was first brought to me, I thought a case had been decided, not a question of an injunction. So it's important that we read the actual documents, we study the actual documents so that we can make informed decisions. Hopefully that you learned some of that here today. Hopefully, again, I keep your attention. You found this interesting, and hopefully you'll come back so I can see you the next time on the Constitution Study.
You have to know wherever you make your stand. Came from a long through line of everyday